about the time, because I think you've all agreed how to allocate the time between yourselves. You do run the danger of any overspend here being taken off the reply.
I do. I understand that, and I will take the consequences and produce my reply accordingly if it turns out to be necessary.
I mean, certainly I will have some questions at the end for you as well, so please factor that in too.
I will do. So, just before lunch, we will come on to the Divisional Court's judgment and how they dealt with this issue. If your Lordships can turn to the core appeal bundle, plan 21, and page 235, we're just going to whisk through paragraphs, the lead up to the key paragraph, which is paragraph 227. So here the Court of Appeal sets out the briefings that were provided to the MSC in advance of their meeting by civil servants. And one of the things that when your Lordship reads through is very notable about this is that all those briefings were full of the negatives, the costs and so forth, with minimal, if any, consideration whatsoever of the factors weighing on the other side of the balance. And at paragraph 227, having set out that background, in the previous paragraphs it sets out the complaints that the claimants were making about the error of fact, and at 227 says this: we are unable to accept that there was a material error of fact as alleged when seen in context. What was being represented was that in real terms the building of an airstrip on the outer islands was not feasible. The Permanent Under-Secretary's remarks were by way of introduction to the full slide pack from the MSC meeting in 2015 and other documents, including the KPMG report and the 2015 consultation, all of which considered in terms the costs of building an airport to service the outer islands. And the MSC had full and accurate information in the slide pack as to the geographical situation of the outer islands and the environmental impacts of development on the scale under consideration in any meaningful sense by reference to cost, environmental and practical considerations. Building an airstrip on the outer islands was not practicable. Now, in our submission, that is an erroneous conclusion. The wording was clear in its terms. Its language is capable of only one understanding, and that is that it was impossible by virtue of the geographical size of the island to construct an airport. It's wholly impermissible to set it in the context that the Court of Appeal sought to set it. It's unquestionably the case that the papers and submissions provided by the civil service did seek to point out the cost and the impracticality of this route to resettlement, but the fact remains that what ministers were presented with was right at the forefront a fundamentally erroneous factual foundation which went to the heart of feasibility, which had a significant bearing on cost, which hadn't been factored into the costs that were presented to the ministers. So the costings that were presented, which we can see are set out at paragraph 223, didn't take into account for one moment a proper costing of the building of an airstrip, if it was an airstrip that could accommodate the dash airplanes as opposed to a full international airport. So it's, in our submission, an entirely impermissible step linguistically for the Divisional Court to have taken. That is simply not what was being intended.
It sounds to me like a finding of fact that the Divisional Court have arrived at on their own.
Yes, that's exactly what it is. And insofar as they've done so, we submit that that is a wholly impermissible finding of fact. It is simply not within the bounds of what they could reasonably have concluded from that sentence. And then the second point we make is they found comfort in the fact that the were presented with a full set of documentation from which they could extract the truth of the situation in terms of cost feasibility and so forth. And in my submission, again, that's an impermissible step. The ministers, and the court is entitled to, and where anxious scrutiny is required, in my submission is required to recognise the reality of the situation. And the reality of the situation on the ground was that ministers would not have had the time to read all this material. They would be very dependent upon the advice provided by ministers, by the civil service. And that advice was very much skewed in one direction in terms of impracticability, cost and infeasibility. And one of the key considerations when the civil service had gone on to consider the outer islands, because the Prime Minister wanted to see what could be done, one of the key considerations was the viability of a tourist industry, and this was absolutely central. Getting this right was central to a proper consideration, both in terms of feasibility and cost. So in my submission, that conclusion of the Divisional Court is simply one which cannot stand in the face of the language and on the footing that anxious scrutiny must apply. Can I then turn to the next error of fact, which we submit arose in relation to the deliverability of the support package. Now, this is dealt with in paragraphs 244 to 245 in the Divisional Court's judgment. This is at page 240, and hopefully we can just stick here with what's set out in the judgment in terms of the key material that is engaged in this issue. So if your Lordships can read 244 and critically what it is the British High Commission has said on the 12th of August in the quoted paragraphs. Then 245 some risks of the delivery of this package, the main one being that the programme in Mauritius could only be delivered through the Mauritian government and would therefore require their consent and cooperation, which might not be forthcoming while the sovereignty dispute continues. And then the final letter from the defendant to the Prime Minister, which accompanied the October 2016 right around. So this is before the decision was made on the contents of the package in November. If your Lordships will read that.
Yes.
And then the complaint that is made before the Divisional Court, and 248, it was misleading to allow the decision on the support package to proceed without clear and unambiguous advice on the likely barriers to its delivery in Mauritius being provided to ministers in terms. And then the analysis of the Divisional Court at 250 through to 252. So a number of things to unpick there.
Yes.
So, first question, are they interrelated? So is the non-deliverability of the resettlement package something that is related to the settlement fund? And if your Lordships will turn to the ministerial statement itself in the call appeal bundle at tab 15, page 169.
Sorry, this is, we're in the core bundle.
We're in the core appeal bundle, and we're going to look at the ministerial statement. It's at page 169, tab 15.
Oh yes, yes, thank you.
It's the decision,
Yes,
communication of the decision
Yes.
on 16th of November.
yes. Yep.
And the decision to provide support is clearly a decision instead of resettlement. That is clear. So the first part of this statement deals with why there won't be resettlement. And if one goes down to the third paragraph, I am today announcing that the government has decided against resettlement of the Chagosian people to the British Indian Ocean Territory on the grounds of feasibility, defence of security interests and the cost of the British taxpayer. And then if one goes to the very bottom of that paragraph and the next paragraph, the government will instead seek to support improvements. And then if we also look at the minutes of the 15th of March meeting of 2016, when the decision was made not to support resettlement, that's at tab 40, page 402. Tab 40, I'm sorry, of the supplementary bundle.
Yes.
And that at 402 we can see the decisions set out, summing up. The Prime Minister said that, and if we look at 2, little Roman numeral 2, the Chancellor of the Duchy of Lancaster would review option C, including options A and B are ruled out 1. The Chancellor of the Duchy of Lancaster would review option C, including the proposed development package, and recommend whether it should be enhanced. And the Department for International Development would fund and help design a package of development assistance under option C, working with the SCO, ensure its delivery, including in Mauritius and the Seychelles. Now, it's clear from 2 and 3 that there would be a support package. The question then is how much, what it's going to look like, what is the shape. So, right from March 2016, ruling out resettlement, but instead. So, the way in which to do something for the Chagosians is no to resettlement, but we will do something via this other option of the refund. And the two are so plainly interrelated. If and insofar as it was impossible for some reason not to do anything by way of funding the option C, the C option, then plainly that would have had a bearing upon considerations as to whether or not resettlement could be pursued. The two were both matters that fell to be considered in determining what could be done for the Chagosians. And then, if we go to the summary of the redacted passages of the minutes in the supplementary bundle, that's the minutes to this meeting at tab 82, page 658. Which you don't have, I'm afraid.
No, we've just got it now. I've just got it.
Ah.
So yeah,
Well,
that's just
I'm
right.
glad. So
Let's just get it up. There's a lot of paper here.
658. Just to underscore that point, which.
So which tab is this one?
It's tab 82.
Yes.
You can see it is the summary provided, because this material is all closed, of the NSC meeting on the 15th of March 2016. Before the NSC took its decision, the NSC is summed up by the Prime Minister. The NSC's discussions recorded in its minutes are redacted for collective cabinet responsibility coupled with the following points. An historic wrong had been committed against the Chagos Islanders, which the government should try to put right. So that's the background that they're considering and the basis upon which they're considering resettlement. And if you can't achieve putting that right by resettling, then you look to something else. So they are plainly all part and parcel of an attempt to achieve some sort of justice for the Chagosians. So again, this is all in the context of requiring anxious scrutiny. So if it transpires that there is a difficulty in relation to the fallback option, as it were, settlement fund, in actually achieving its delivery, then that is something, as a matter of rationality, that ought to be taken into account in deciding whether or not you should instead pursue or seek to pursue, take further steps to ascertain the full cost and so forth of the resettlement option. So insofar as there was, and we submit the High Commissioner's statement plainly shows that there was, a real problem with the delivery of that fund, that is something that needed, again in the context of anxious scrutiny, to be put before the decision makers in the clearest of terms, so that the decision makers could understand that that which they wanted to do to try and put right the problem may actually, well, would actually have no chance of achieving that end. And
I think I'm going to have to ask you to bring your submissions to a close, Ms. Kaufman.
Yes, okay, I'm so sorry, I shall do that. So can I just ask the court then the simple point on that is then that what was relayed to ministers at that time, which the Divisional Court considered to be an adequate summary, simply did not reflect the true scale of the impossibility of the delivery of the package. And your lordships may have noted that that package still hasn't been delivered at all. Even during these times in the COVID emergency, the Mauritians, the Chagosians have seen nothing by way of delivery of the package, which was entirely consistent with what the High Commissioner said would be the problem. Just finally, before I finish, the other factors we've identified at paragraph 57 of our skeleton are simply matters that are contextual. They underscore why it was so important for the court to have anxious, apply anxious scrutiny. Unless, well, I think you've indicated you do have questions.
Yes, I do. Thank you very much indeed for your submissions. Yes, can I just go back to this very important submission that you made, a fundamental one, which is about both in customary international law terms, as you put it, the importance of the right of abode and the right of self-determination, and also your submission connected to that this form part of the common law of this country. And your point, which is a very important point, a linchpin of your argument, is that this was not the point from which the decision makers started, as they should have done, and therefore the starting point being wrong in itself, this was a fundamental error, certainly not sufficient to satisfy the requirement of anxious scrutiny. And really what I wanted to ask you was this: why wasn't that an argument which could and should have been brought in Bancourt number 2 or number 4? That's really the point. Why couldn't it and why shouldn't it have been brought then? If it could and should have been, why should we be considering it now?
So can I start with Bancourt number 4? Bancourt number 4, it couldn't have been brought. The issue in Bancourt number 4 was a totally different issue, which was seeking to reopen the Bancourt number 2 on the basis that there hadn't been a proper disclosure in relation to the evidence of the feasibility study. So that simply doesn't enter into it. But Bancoot number 2, the argument being put in Bancoot number 2, the primary argument, was that the nature of the right of abode was so fundamental that it acquired a constitutional status that meant that you couldn't abrogate it at all by way of statutory instruments. So the argument was a much, much more powerful argument reliant upon the right than anxious scrutiny. But certainly, anxious scrutiny was an issue that applied in relation in Bancoot number 2, and you can see that one of the judges, I think it was Lord Carswell, did apply anxious scrutiny, and certainly Lord Hoffman understood the significance of the fact that the court was dealing with a right when he referred to the case of Sims and O'Brien in relation to statutory interpretation and the limits on abrogating rights. So it was in play.
It was in play, but they dismissed, but they allowed the appeal, the majority, on the ground that irrationality was not established.
Yes, but irrationality. So we are in the field of irrationality here. We're not in any different field to the field that applied in Bancoot number 2. But within the field of irrationality, because there is a fundamental right at stake, one has to approach irrationality through a prism of anxious scrutiny. And that is what Lord Carswell did in Bancoot number 2. And it's not quite clear what the other judges did. And it may simply be that sight was lost of the importance of anxious scrutiny because of the way in which the case was framed, which was that it was put on a much more fundamental basis than anxious scrutiny.
Yes, but you see, my point really is this: in most areas of litigation, if you could have taken a point but didn't, and the court has reached a conclusion inconsistent with the point, you can't normally raise it later on. And insofar as this is effectively a rerun of an irrationality argument, of which this could have formed part, and I think you're saying it probably did form part, why should we not just regard ourselves on this part as being bound by Bancoot number 2?
So let's take a step back. We are not challenging Bancoot number 2. So we can't be accused of not taking, of trying to take a point that wasn't taken in that case. The 2004 order stands. We are not challenging the 2004 order. We are challenging a different decision, and that is the decision not to reconsider, or to consider whether to restore the right of abode, even though a decision was taken not to resettle. That is, the refusal, a failure to look at the right of abode in its own right. Now, that is not a challenge to the 2004 order. Our challenge is to the decision not to consider revisiting the 2004 order. So it is a difference.
No, but
we are targeting something.
I understand that. All right, let me just, because let's not have too long a debate about this. I think I've got your point, but just to kind of round it off, it would have been a relevant argument in saying that the decision to make the 2004 order was irrational because they'd not started from the position in making that order of the customary right of the, and common law right, of the Chagosians to remain in their home. That would have been part of an attack on rationality, and I think you were saying it was indeed raised as such.
Yes. I mean, in Bancoot number 2, right at the forefront and at the heart of the case was the right of abode, which was taken away by the 2004 order. The judgments themselves do not, in terms, save for Lord Carswell, engage with anxious scrutiny, but it is clear that there is a recognition that one is dealing there with a common law right for the reasons that I went through earlier on. But the key point is, irrespective of how the court approached Bancoot number 2, this court and all courts must apply the law. And if anxious scrutiny is required, then it is required. if that is what the law entails, then the decision maker must engage in it, and the court must review it against that background and within that framework.
Understood. Thank you very much. I don't know whether Lord Justice Dingemans has any questions.
Thank you very much.
Lord Justice Green, any questions? No. We're extremely grateful to you. Thank you very much indeed, Miss Calvin. Yes, Sir James, ED.
My Lord, I'm hoping you can see and hear me.
We can hear you, we can't see you yet.
Oh. It sometimes takes a little while for images to pop up. Is that
Not yet, not yet.
better? Oh,
Not yet, but it may do so. The main thing is we can hear you.
good. Well, I haven't been able to see Lord Justice Dingemans all morning, so I'm sorry about that. As long as everyone can hear, perhaps, that's
No,
the least we can have.
Well, we can all hear you very, very clearly. And may I just say, we quite understand that you've so far lost half an hour of the time allotted to you. And so if you have to move into the time reserved for the reply to some extent, well, we'll have to just bear that.
My Lord, I'm very grateful. Being suggested to me by email that I log out and log back in again, but perhaps if you can hear me, that's good enough for the time being.
Well, it's entirely up to you. I mean, if you'd like to do
Shall I
that,
just try and log out and log back in?
Certainly. Certainly.
Give me one moment. Word.
Yes.
Well, I've tried it. I don't know.
Yes. No. Yeah. We've now got an image of you.
Dingemans, that's progress.
Yes.
Okay.
We can
You
see
now
you.
as well. Good. My Lord, just before I start, and on the point that my Lord was just raising, and in case I forget it, could you take up, please, the first of the authorities bundles and go to Bonku number 2. Behind tab 16, if you're working electronically, the first page of it I want is 428. And it goes to the improbability of Sir Sidney Kentridge having missed a point of this significance. As we can see from the bottom of page 428, paragraph on that page, and reading over to the next page, 429, just below C, the arguments about customary international law were directly and squarely raised, based on the right of abode, and based on an assertion that the customary international law is part of the law of England. Right?
Yes.
So that's the argument. If you go forward to page 447, you go to paragraph 66 of the majority judgment given by, the majority speech given by Lord Cotton, you will see what the court made of it.
So this is paragraph 66, is it?
6. It is.
Yes. As I understand,
That's helpful, at least in
well,
relation to that.
it is, as I understand the answer that I've been given, which is, well, we're looking at a different decision now. There's not an attack on the constitution order, but rather on the decision that's been made here in relation to resettlement. I think that's the way the answer's put.
Fantastic the way the answer's put, but I thought it was right to draw your attention to the fact they had actually thought about it, considered it, rejected it in terms. I'm not going to get sucked into this debate now because I'm going to have a section on my submission dealing directly with this point, but the answer is going to be that the customary international law is not simply part of the law of England, and the logic that Lord Hoffman and the majority set out in paragraph 66 in yours.
Thank you. All right. Thank you.
My Lord, just to go back, I want to tell you what the shape of the submissions is going to look like. And I wondered a bit about how best to do this, but I'm going to do it in this way if that's acceptable. I'm going to make 2 or 3 preliminary points, principally about the nature of the process. Then I'm going to come to the standard of review, to anxious scrutiny and all that. And that in part will take into and that will draw in what I've described as the resurrected rationality challenge, limited that just been going through, because that goes at least to materiality of any error of principle if there was one. Then I'm going to have a section which deals with the ICJ advisory opinion, a block. I say as a block, I'm going to deal with it as a block insofar as its relevance to anxious scrutiny, to customary international law, to the impact on common law, and then I'm going to come to the ECHR. So the bit on the ICJ advisory opinion first up is going to leave some bits of it to come back to, particularly when we're considering the issue of jurisdiction for the purpose of the ECHR, and what it tells us about the meaning of the words responsible in Article 56, X, Article 63. So that's going to be the structure. So I'm going to try and do the ICJ advisory opinion submissions in well, a chunk and a half, if I may. And then finally I'm going to make some very brief submissions about the support package.
Thank you.
So far as preliminaries are concerned, you'll be aware from the skeleton that the position of the Secretary of State is that the Divisional Court were right on each of the grounds of challenge for the reasons that they gave. And they were particularly right, if I may say so, in the detailed description. I emphasise this because I'm not going to go back to the detail of it. Their detailed description, both of the factual and legal context, which they deal with, if you have the judgment to hand, it's called Bundle Tab 21 if you wish. Tab 21, and it's the judgment at paragraphs 12 through 19, where they set out the factual and legal context, including all the previous litigation and so on. And then in particular, in the long and detailed section of their judgment, between paragraphs 20 and 84, reviewing what preceded the decisions, the various decisions, and describing in considerable detail the nature of the decision-making process, including going through key elements of the KPMG report. And I focus particularly, by way of my first preliminary point, on the points that emerge relating to the decision-making. I do so particularly because the thrust of the argument which is now made against us is not, it appears as it was below, a challenge, at least principally, some indirect challenge to it, to the substantive decision itself, but a challenge to the process by which the decision was made. And it's right, therefore, to draw attention to 5 particular features, if I may, that characterise that decision-making. The first is that the decisions were considered at the very highest level of government. They were considered by multiple secretaries of state, by the NSCO, which is the officials group which precedes National Security Council decision-making, by the NSC itself, and by the Prime Minister. There was direct Secretary of State involvement, multiple Secretary of State involvement, and Prime Ministerial involvement, which continued throughout the decision-making, right up to the point of the ministerial statement in November 2016. So considered at the highest level. Secondly, considered with the most conspicuous care, and with the historic wrongs done to the Chagos Islands front and centre. And my learned friend Ms. Kaufman this morning took you to various passages in which it was made entirely clear, I think by reference to the Hayes statement, Mr. Hayes' statement, with the Prime Minister then, David Cameron, saying we're coming at this decision-making with a view to seeing what we can do to deal with those historic wrongs, but considered with conspicuous care. It involved a considerable and prolonged analysis by a range of departments and ministers. There were a series of detailed and expensive independent studies including reports in 2000 and 2002, dealt with in Hayes 1, if I can give you the reference, by reference to his first statement, Hayes 1, paras 30 to 34, and that's in Supplemental Bundle 2, tab 88, pages 6, 8, 8 to 9. And a report which you're well aware of from KPMG, with all its length, detail and complexity, which took a year in the design before even getting to them. See Hayes 1, paragraph 50. And I emphasise that it involved a concern to do what could realistically be done to what was acknowledged to be the historic wrong. And the Prime Minister was active and evidently sympathetic, wanting all the options properly and carefully explored. Continued, as Mr. Hayes' statement makes absolutely clear. See, for example, para 102 of his first statement on the PM's reaction to the KPMG report. And it involved and included the decision-making process, the unusual step of no recommendations being made to the NSCO, but with the Foreign Office giving a neutral presentation of all the options. Again, Hayes 1, paras 107 to 108, but with the Secretary of State for the Foreign and Commonwealth Office separately communicating his own recommendation, as did other NSC members. So far as the chronology of the decision-making is concerned, still on the care with which it was taken, the Divisional Court overview is at paragraphs 20 to 35. At 36 to 51, they give you probably as much detail as you will need, at least to put you in the picture of the KPMG report, 36 to 51 of their judgment. And then the detail of the decision-making process is 52 to 84 of the Divisional Court's judgment. We sent, and I hope the Court will have received it, on Monday, we sent a cross-referenced section of the Divisional Court's judgment, 52 to 84, so that if you wanted to, in your reading, you could bounce from there into the underlying documentation. So you should somewhere, if you haven't got that, I'll make sure it comes again, as it were. But I'm not going to go through it in any detail now, but you should have a document which will enable you effectively to move from that bit of the judgment of the Divisional Court into the underlying documents to the extent that you may wish to do so. But in a nutshell, the sequence, the main blocks consisted of the following. December 2012 to the KPMG report in January 2015. There was a matter consideration even before the KPMG report was produced to all the various options. See Hayes 1, paragraph 41 and following. Then there was the first NSC meeting on the 10th of March 2015. See for a summary of that, Hayes 1, paras 96 following. There was the NSA briefing to the Prime Minister in February, at the end of February of 2015, which preceded that meeting. And if you have the Divisional Court judgment to hand, just to pick up the main events as we go through, you will see that that is the briefing from the National Security Advisor, National Security Advisor, to the PM in February, saying what the Divisional Court quote in paragraph 66. And 2 weeks after that, that was 2 weeks after, just tracking back in time, that was 2 weeks after the position of the Americans had been set out in the Gotama letter that is quoted extensively paragraph 63 of the Divisional Court judgment. Effectively shutting off Diego Garcia from any active or real or useful participation in any resettlement plan there might be, which obviously has significant impact on the viability and the costs and everything else, given that the only viable airport of any size was on Diego Garcia, and that's used by the Americans for military purposes. There's then further work taken forward that had been identified at the NSC meeting of March 2015. That's described at some length in Hayes 1, 148-223. And there's then the second NSC meeting in March, 15th of March 2016, Hayes 1, 223 and following. The NSA, the National Security, briefed the Prime Minister, and you see that summarised at paragraph 70 of the Divisional Court judgment at 71. See in particular what he says about the Outer Islands option in the quote of paragraph 70 of the Divisional Court judgment. And his recommendation recorded at paragraph 71. And just to put you in the picture in terms of the underlying documentation, if you do now have the second of those supplementary bundles, not the authorities, the other ones, I'm hoping the Master of the World will have a physical version delivered. I'm not sure whether they would have made it to Lord Justice Green and Lord Justice Dingemans. Maybe there's an electronic version. If not, can I just give you references? But I just wanted to show you one set of documents because they're quite useful by way of summaries. If you go to tab 81,
Yes.
you'll see that there have been various.
Sorry to interrupt. Can I have
81. Yeah, 653. 653.
Yes.
What this does is effectively operate as an open minute of the discussions and what was said at the various meetings. And if you just flick to the next tabs, it's called CCR Summary 3. I think CCR stands for Collective Cabinet Responsibility. So it's the product of the security processes, and this is what's gone into open, as it were. But these are the summaries of those meetings. So if you go to the next tab, or electronically you go, for example, to 658, you will see a further document of the same kind. And again, tracking forward, you have various other summaries of meetings or of cabinet consideration of the kind you see going all the way up to November. So those 4 or 5 or 6 or 7 tabs contain, as it were, the running summary in open of cabinet consideration and things they were thinking about and discussing. And so they're a useful set of documents for seeing the sorts of concerns that were in play. So to take by way of example 653 in the electronics, which is the March 2016 meeting, you'll see the first bullet on that page. The government has been clear and so on. You see the final bullet on that page. You see a consideration at the bottom of 654 under resettlement options of the various bits and pieces on costs. The relationship with the US is dealt with by an italicized heading and then 2 bullets, just by the hole punch on 655. The risks of small isolated island communities, final bullet on 655. Outer Islands option given specific consideration on 656. Which then goes on to deal with non-resettlement options in the remainder of that page 656. So there's then, as the next phase in the decision making, the development of a support package from April 2016 onwards, and various further discussions as dealt with Mr. Hayes' statement between Prime Minister Cameron and President Obama. There's an NSC meeting in March 2016, as we've seen. That then runs to the final decision in November 2016. Dealt with that period between March and November is dealt with in Hayes 1, 249 to 285, and then the final decision at 286 and following those paragraph numbers. So it is jolly difficult, I think, to think of any sort of single issue, multiple issue decision that would have attracted level of scrutiny at the highest echelons of government, with all the things that fed into it, and it's extraordinarily difficult, all the more so on appeal, to convey any real flavour of the sheer level of detail and care that decision making entailed. And I simply make the point about conspicuous care and leave it there. And the third of the features of the decision making.
So, James, just before you go, you'll probably come to court, of course. The argument that's being advanced against you is not that very care wasn't taken. It was an intensive review. I think it is more along the lines that there were simply mistakes made in the course of this intensive review, and to be thrown into the scales was insufficient weight to the fundamental nature of the rights concerned. But it seems to be obvious that it was a review conducted intensely. But it may just be errors in the quality of that intensity which is really being challenged. And I see
I'm not quite certain, and I'm going to come to those very specifically, if I may. But the point taken, that does indeed seem to be the thrust of the challenge. But it's important if one is considering a challenge which says you didn't do anxious scrutiny, and if only you'd done anxious scrutiny, you'd have done things differently. It is, I respectfully submit, at least not, with an emphasis of what actually happened and the degree of scrutiny which was in fact.
Yes, you've established intensity.
Well, that's good enough for now, for my purpose. Third feature to emphasise then in the decision-making process, it was considered with the active and detailed involvement of those affected or potentially affected by it, namely the Chagos Islands. And see for that purpose Hayes 1, paragraph 51, for the Chagos Islands involvement from the outset of the review in 2013, and see also 53.2 in that statement and 58 in that statement. And for the transparency of the process, see Hayes 1, 66 and 69. The fourth, and perhaps I can merge the fourth and fifth together, the fourth and fifth submissions about the process, as is evident already to you from just a brief look at that CCR document, the decision making involved a series of judgments about matters that simply don't admit of a right and wrong answer. There are evaluations at almost every level, and many, if not most, are predictive in nature, including about the ability or not to create a viable economic setup, the real possibility of serious social issues associated with remote communities in very harsh conditions, and so on. Those features render the decision-making here at heart political, in the sense in which that word is used in the jurisprudence. Specifically, and I'll come back to these, it involved, as at least three key strands, defence and security. That hardly needs any further citation. But as the Divisional Court judgment at paragraph 30 in the very outset makes clear, from the outset, November 1965, the separate territory was created or constituted precisely in order to serve the defence interest of the United Kingdom and its main ally. And a year later there was then the exchange of notes, which said in terms, as the judgment records in that paragraph, that the BIOC shall be available to meet the needs of both governments for defence. And that would remain so indefinitely, a position which is unaltered in substance today, and certainly inured in 2016. So defence and security is one, international relations is the other. Again, you have the clear flavour from the outset of the judgment. US relations obviously very squarely to the fore, but the rumbling and continuing diplomatic disagreements with Mauritius. And thirdly, the decision-making involved macroeconomic and social issues, involving the balancing of a series of competing interests. Very, very large sums of taxpayer money involved, on top of the other monies already paid in full and final settlement. Real questions about the creation of a new society in conditions not currently set up for that, with all the long-term governmental commitments that the creation of such a society would entail. So in conclusion on that, you have an extraordinarily prolonged and careful process of consideration, intermeshing strands of decision, a range of views possible reasonable on each of them, a range of views possible on the weights to be given to each of them when you've done the initial evaluation in the final decision, and a range of possible views on how they should relate to each other. So that's the first thing I emphasise about the process of decision making. The second thing I emphasise by way of preliminary remark is on the care and detail of the Divisional Court's analysis. And specifically, nothing has changed since the Divisional Court's analysis, leaving the ICJ aside, on the decision-making process for obvious reason, or on the facts and bases for the judgments that fed into that decision. The judgment is one of enormous care and detail. It was arrived at after very careful consideration of a mass of evidence over a number of days, which simply can't be replicated and shouldn't be expected to be replicated in this court. One can get a flavour of it if you just go to paragraph 11 of the Divisional Court judgment. They had 16, as you see from the penultimate sentence, 16 open trial bundles, 2 bundles of closed material, 6 bundles of authorities, alongside open and closed skeleton arguments. The third point to make as a preliminary matter, I should say just in relation to that, paragraph 326, that at these chimes, that perhaps leads into my third point, which is called moving target. It rather chimes with what the Divisional Court were kind enough to make at the end of paragraph 10 of their judgment. great song and dance about permission, because we've had lots of argument, and you'll no doubt form your own view about whether you do or you don't want to consider particular points. But I do simply make the point that it makes litigation extraordinarily difficult and onerous. If you have what we have below, and to some extent we have here, which is a constantly moving target about the nature of the arguments that are actually being deployed, with one just about perhaps being able to find a hook in a single sentence of a pleading or a skeleton, or sometimes not even that, with points being taken orally that haven't been fully or properly developed, either in grounds of appeal or in the skeleton concerned. As I said, it's a matter for you what you do about permission, but it's not in the bundle, but you will be very well aware of what Lord Justice Singh said in the Talpada case, and what Lady Justice Hallett said in the same case about the importance of ensuring that if points are going to be taken ultimately in the appeal, that they are properly the subject of permission, and that people stick rigorously within the bounds of the permission that has actually been given. As I say, I don't wish to make a song and dance about it, but we've had a very different flavour in relation to quite how the anxious scrutiny case is put. I think I'm right in saying that at no point below was there even a suggestion, which I will come back to, that anxious scrutiny in some way, shape or form affected the decision maker, as opposed to providing a yardstick for review by a court. At no point below have we ever had any suggestion that customary international law was part of domestic law, and for that reason provided a freestanding basis of challenge. And in relation to the reopening of what are said to be errors of fact, certainly at the permission stage of this case, the position that was taken was that there had been an error of principle. It was said in relation to anxious scrutiny. And the question that was then raised was whether or not, even if there had been, that was material for the purpose of the reasoning and conclusions of the Divisional Court. And it was subject of the invitation to identify specifically where something was said to be material that was dealt with in the permission hearing, but no permission was sought or given to start remounting errors of fact as a freestanding ground for appeal. That's what I wanted to say. So that's my short moan about permission and all that out of the way, and I can move therefore to the standard of review, if I may, as the first of the substantial topics to be dealt with.
Thank you.
My core submission essentially supports the correctness of the Divisional Court's analysis between paragraphs 101 and 109 of their judgment. And the first submission I make is that rationality is the standard as they correctly concluded. The test is not, and no one now asserts that it is, but the test is not. It may be interesting or relevant to note this, given that anxious scrutiny is a facet of some types of rationality challenge, but the test is not proportionality. That was the argument that was run or floated below, and the judgment dealt with that on the basis of the Court of Appeal authority of Brown. Don't need to take you to it or to go to it. Judgment paragraph 95 to 100 deals with the Brown case and anchors this case not in proportionality but in rationality. And there are good reasons why it's a rationality standard, as the Divisional Court concluded, because the constraints that are imposed on the manner of the court's review are based on and shaped by rationality's constitutional foundations. The court's function is properly one of review. It is not decision maker. Under the Constitution, the primary decision maker is the executive. And here, at the very highest level of the executive, the cabinet, with a number of relevant secretaries of state and the Prime Minister involved. consequence is that it is for them to assess and for them to evaluate and make decisions with all the leeway or breadth or margin that is inherent in the concept of rationality, including the intensity of review. That exists for sound constitutional reason, which is to respect the primacy of the decision maker under our constitutional arrangements. And that standard means that the judgment which is made as a matter of substance, if it is to be challenged on that ground, has to be outside the bounds of decisions that a reasonable decision maker could take. The famous description of Lord Green in Wednesbury itself, recently recited by the three-person Divisional Court in DSB, Core Authorities, tab 21, page 833, at para 135. I don't invite you to turn it up because the words are engraved on, I'm sure engraved on everyone's heart, something so absurd that no sensible person could ever dream that they would have the authority. DSD as a divisional court was also endorsed by the Brown case. Just in case you wanted Court of Appeal level authority endorsing that approach. Don't invite you to turn it up again, but supplemental bundle of authorities, tab 31 is the start of it, paragraphs 50 to 51 at page 1645 in that supplemental bundle. And rationality, it's as well to emphasise this, rationality as the standard applies to three different aspects. It applies first of all as to what process to follow and what matters to inquire into and how to do so. So the consideration of how to approach the question of what is needed to be taken into account in the context of statutory decision making and indeed non-statutory decision making, the decision in DSD, maybe worth just turning it up for this purpose. Core bundle of authorities number 1, I think, tab 21, page 833 in electronic.
What was the tab number again, please?
Just lost it myself now. 21, my lord, sorry.
Thank you.
So just picking it up as we if you go to 136 to start off with, on page 833, you'll see the title. I should have pointed out the title of this section of the judgment just above 134, failure to have regard to relevant considerations. And they cite in 136 the very well-known passage from Justice Cook, Creed NZ, and not statutory decision making. Effectively, the conclusion is matters expressly required to be taken into account by the statute. And the ordinary rule then, in the paragraphs that follow, I'll come to the particular ones in a moment, but the ordinary rule is it's for the decision maker to decide both what factors to take into account, in other words, what it considers to be relevant to the decision to be made, and the manner and intensity of the inquiry that it undertakes. And that's subject and subject only to a rationality long stop. Look at 137. Particularly the final final sentence. A matter is so obviously material to a decision on a particular project, it would be Wednesbury unreasonable for the decision maker to ignore it. And see especially Lord Justice Laws in the Cartoon decision, quoted at 140. So you've got a rationality standard built into the decision making that is involved in how you go about the decision making process and what matters you should or shouldn't take into account. And here we're in non-statutory decision makings. It's rational judgments for the Secretary of State or for the Prime Minister. The second thing that rationality attaches to, and it's perhaps as strong as anything, is the weight to be attached to various different considerations. That is paradigmatically for the decision maker. And thirdly, the final decisions involving the balancing of the various factors and interests involved. And if you've got multifactorial or multidimensional decision making as we have here with various strands feeding into them, as I emphasised earlier, the weight of each of them is for the Cabinet. The weight relative to each other of each of the Cabinet. And the ultimate decision is ultimately for the Cabinet. I mentioned the various matters that led to particular respect being accorded to the decision maker. To some extent, although they have been referred to in rationality cases, there's much less need to refer to them in the context of rationality, because rationality as a standard already has built into it very considerable respect according to the decision maker, precisely because it's a rationality standard. If you wanted authorities which serve to emphasise in the much more fraught from government's perspective contexts of either EU law analysis of proportionality or ECHR law analysis of proportionality, that's where the battleground has been fought as to how the particular sorts of factors that I mentioned earlier on play out in terms of the court allowing greater margin, greater respect or lesser respect. So for security and defence, just by way of one example, Lord Justice Laws in Al-Rawi, it's a different Al-Rawi to the normal Al-Rawi, but I'll give you the reference and don't invite you to turn it up. It's paragraph 148 of Lord Justice Laws in Al-Rawi, Supplemental Authorities, tab 17, at page 805. The best authority, it might be thought, on international relations and all that is the Carlisle decision in the Supreme Court. Core Authorities, tab 17, page 493. In particular, see the important analysis of Lord Sumption between paragraphs 19 and 34. And that was a case, as you may recall, involving a decision by the Home Secretary to refuse permission to an Iranian activist to come and address members of the House of Commons in Parliament. And so Article 10 rights were engaged, and the question was, could that be trumped by our fear that Iran, albeit illegally on the international level, might react thoroughly inappropriately and start taking steps against our embassy in Iran? But there's an important analysis as to the reasons why, even in the context of proportionality and the balancing of full-blown human rights, you accord respect to the decision maker. And those same features, I say, apply to, and are to some extent already built into rationality. And on money and macro and social decision making, it's probably 24, and Lord Newburger between 61 and 65. And that's in Core Authorities Bundle tab 18, starting at page 564. So those three features of the decision making attract the rationality standard. Now, I fully accept what I think my Lord Justice Green put to my learned friend. I fully accept that rationality is, of course, itself context specific, and it does, to some extent, of course, and anxious scrutiny is an example of this, depend upon the context and the precise nature of the right that is involved. I think my Lord the Master of the Rolls put the point to my learned friend that said, well, is this any different to the sort of principled approach that is applied to the standard of proof, where the standard of proof, as it were, remains constant, but it nevertheless fluctuates depending upon the seriousness of the finding which the court is invited to make. It any more than saying that the seriousness of the issue, which is a relative thing, affects the approach of the court to intensity. And I wouldn't respectfully dissent from that broad description of it. So I'm entirely content to accept both the point made by my Lord Justice Green, which is that rationality itself is, perhaps I ought to put in the caveat to some degree, because it's still rationality. It is a context-specific thing, and to accept the way in which my Lord the Master of the Rolls put it, at least for trying to flush out the basic approach to the issue of principle. But against all of that, it is also critically shaped in terms of the context and what that does to intensity and to respect. It is critically shaped by the factors I've just mentioned. So if you have a decision which involves defence and security, which involves macroeconomic or macro-social decision-making, which involves international relations, which is predictive, which is multi-factored, all of that feeds absolutely directly into intensity and respect. Can I just note two other relevant aspects of the rationality principle? The first of them is that there was, as you see from the judgment below, some consideration below, much less here, although there's some parts of it bear on this, there was some consideration of the separate principle set out, I think, in the health stores case that you have behind tab 13, and that was referred to in particular in the judgment of the Divisional Court at paragraph 214. And those are the principles that the minister should be provided with all relevant material for the purpose of making his decision. And again, I don't want to take up time going back to the case. The principle is very well known. The point perhaps to emphasise is that there will inevitably be in all government decision making judgments that need to be made about what does need to be drawn specifically to ministers' attention and what can properly, as it were, be taken into account by the civil service and those who are assisting, and either summarised or even left entirely with a tighter set of factors being presented to ministers. And again, rationality applies there. Is it something, is the test under health stores ultimately, is it something that the minister simply could not have taken his decision without? That's ultimately the test. See paragraphs 62 to 64 of healthcare and 75 and 81. And I think that that is a point to which my Lord the Master of the Rolls will be well alert, having given the judgment that he did in the Seabrook warehousing case, which may or may not spring immediately back to my Lord's mind. If you wanted to refresh yourself of it, it was paragraphs 40 to 45, essentially on the same point. Supplementary Authorities 19, page 835. Again, I don't intend to turn that up. That's the first additional feature to bear in mind. The second one, it was referred to in the Divisional Court judgment of paragraph 216, and that does go to the principled approach to be applied to the sort of challenge that my Lord Justice Green was inviting me to recognise was the substance of the challenge here, which is effectively error. And the principles, as far as that is concerned, are set out in the E case, E and the Secretary of State for the Home Department, Call Bundle 12, tab 12, page 234. But I don't think there's any dispute between us of the correct principles to be derived from the judgment of Lord Commonwealth, Lord Justice Commonwealth, as it was in E, are set out in the Divisional Court judgment here at paragraph 216. But it's as well to bear in mind that there are some deliberately tightly drawn conditions before you can make good a claim of mistake of fact, and they're based on the concept ultimately of manifest unfairness. So our first submission under this head is that rationality was the right standard to apply, but the Divisional Court was correct to do so, for all of the reasons that they gave. And the second
think we're all back on. I don't want to mislead you, Sir James. You are visible, but it's a kind of a postcard picture of you. It's fixed without movement.
Shall I log off and log in again?
Well, it's entirely up to you. I mean, I think we're following everything you're saying. So I don't think you're losing anything by not, without our being able to see your sort of facial features. But it's entirely up to you.
Will you give me 1 second and I'll log off and log in again?
Yes, of course, certainly. Yes.
I don't know whether that's made it better or worse.
No, you're just. Hang on. Let's see if anything changes. Oh, hang on. Hang on.
I've got him appearing as Karen Beale now.
He was appearing as Caribbean. I now have you. Right, I've now got you up with your video marked crossed through. Can you just see if you can run your video?
I'll turn it off and turn it on again.
Yeah.
Has that made any difference?
I'm afraid not. I'm afraid not at the moment. Anyway.
Just give me one. I'll do one last attempt at reboot. Otherwise, it'll just be a voice. I'm afraid.
Fine.
Well, that may be the final attempt.
No, I'm afraid it just hasn't worked. But I wouldn't despair. As I said, hang on. No. You're coming up as somebody else. I'm afraid. I think.
I can now see you, but I can't see anybody else.
Well, I'm sorry about that. It's a very bad outcome.
Anyway, I suggest you plough on, Sir James. I said your submissions are perfectly audible and clear.
Okay. My Lord, I was on whether fundamental rights are in place as to engage anxious scrutiny.
Yes.
I referred you to the judgment, paragraphs 103 and 104. My first and core submission in relation to whether fundamental rights are in place as to trigger the anxious scrutiny doctrine is that you need accurately to place the rights and interests that are truly in play. And you need to do so as of today, or more accurately as of 2016, as forming the key part of the context. So the submission of principle, if you will, is that whether they are or they are not, to what degree rights and interests are in play, is to be judged A, as of the date of the actual decision under challenge, and B, having regard to the true state of play at that date. And I emphasise that because we have never sought to defend in this litigation the treatment of the Chagosians in the 1970s. However, that treatment did not endure forever so as to provide, as it were, everlasting anxious scrutiny, as if the decision taken in the 70s was subject to challenge. The correct approach, we submit, is to assess the scrutiny issue by reference to the issues arising today and the extent to which the decisions in fact being challenged impinged on various rights or interests.
Well, can we be quite clear about this, because it may or may not be important, but do you mean at the date of the decision, which is 2016, or do you mean at the date of today?
No, I mean the decision 2016.
All right.
This is our challenge.
Yes, quite.
And the question is whether it's 2016.
Thank you.
So that is the resettlement decision in the circumstances prevailing in 2016 plus a support package. And it recognises, therefore, at least the following. 1. Events have moved on. The historic wrong has been squarely acknowledged and was at the forefront of the new review and decision-making process. 2. There is no settled civilian population in the buyout. No Chagosians have lived there since 1973. Settlement would thus involve a new society being created after 45 years of none. and that plainly impacts on viability and costs and all the rest of it, and is relevant to the nature of the interest involved. 3, there are no private rights involved. It's all Crown land and always has been. 4, the 2004 order, whose legality was put beyond doubt by the House of Lords in Bonku number 2, indicates and establishes that no right of abode has existed since that date at the very latest. And as the judgment repeatedly and properly said, see for example 104 and 110, there is and could be no challenge to the 2004 orders, which were challenged unsuccessfully in Bonku 2. 5th, many of the Chagosians have moved on. None of them is stateless. Many have British citizenship, and others have moved into Mauritius or the Seychelles, as the Divisional Court acknowledged in paragraph 18. And finally, they have been paid substantial amounts of money as recompense for the historic wrong, for the displacement.
Now, is that true of those living in the Seychelles?
My Lord, I don't think that they signed up to it, and I'll come back to this in the context particularly of the victim status point under the ECHR. I think the factual answer to my Lord is no, but that comes with the caveat that there have been express findings of fact by Mr. Justice Ousley in the case that was the trigger for the Chagos Islanders decision in Strasbourg, that the people who lived in the Seychelles could have found out about the litigation and could have taken part in it. And it was for that reason that the Strasbourg court reached the conclusions that it did in relation to them, where that specific argument was run.
But I think strictly speaking, your 6th point should say the Mauritian Chagosians have been paid a substantial amount of money for the displacement. You may want to go on and say something else about the Seychellians, but I think that would be a more accurate way of putting it.
My Lord, it would, as long as the caveat or the rider is attached.
Yes, quite.
Which is, see Mr. Justice Ousley making findings that actually they could have found out about the litigation, could have participated in it, could have participated in the settlement.
Yes.
And I'm not going to turn up Mr. Justice Ousley now, but for that point, can I just give you a reference? It's in Supplemental Bundle, tab 12, starting I think at page 284, and the relevant paragraphs dealing with that point about the Chagosians in the Seychelles are 89 to 90 of Mr. Justice Ousley's judgment, 494, 571, and yes, it had this number of paragraphs, 684 to 685. And pretty much all of the points that I've just made, I respectfully submit, are collected in and formed an integral, if not the core part of the reasoning of the House of Lords in Bonku 2. Can I invite you to take up tab 16 of the first of the core volumes of authorities, again if you would, and go to paragraph 53 on electronic page 444. Just to place paragraph 53 in its context, paragraph 53 is in direct reaction to the anxious scrutiny citation and analysis of Thomas Bingham in Smith. And you see the submission that Sir Sidney made, recorded in the quote in the tail end of paragraph 52. That's the context. And as he says in paragraph 53, second sentence, having cited Smith, I think it's very important that in deciding and so on, invite you to read 53 through to the end of 58, so you get the analysis in its entirety. But most of the points that I've just made are collected in 53, but 53 to 58, if you would just remind yourselves of those paragraphs.
Yes.
You'll see the nature of the analysis. I mean, to some extent, it cuts the anxious scrutiny argument at its knees. Because what he's effectively doing is to say, well, I can take that. All right, I'll take it. Let's assume it's anxious scrutiny. It doesn't matter. Because the world has moved on when you're looking at that side of the balance in terms of assessing the weight of interest that might attract the greater degree of intensity. And in any event, you feed in all of the other matters which I mentioned, which are just as applicable in 2016 as they were then. So in other words, we do respectfully submit that that is a complete answer to anxious scrutiny. But in any event, and just for completeness, if I may, one can get sucked into the interstices for no very good reason. I don't want to lose sight of the fact that this is the prime point. That the historic right of abode, whether there was a historic right of abode, is itself controversial, to put it at its lowest. So that's the second set of submissions, which are a little more complex, but fundamentally it might be thought don't matter terribly in the light of the first prime answer. And that is because we don't accept the way in which the appellants have sought to analyse the various pieces of local legislation bearing on this. The position we submit is as follows, if I can give you this tolerably quickly. The 1971 Immigration Ordinance, Supplemental Bundle 3, tab 3, page 29. It imposed immigration controls on those visiting the buyout. And in section 9.2 of it, I don't invite you to turn it up, it said no person shall be entitled to enter or be present except as authorised. And then there was authority that was potentially given by way of permission under section 4. That was subject to additional provision in the buyout immigration order at section 5, effectively requiring permits to enter the territory. See our skeleton, para 17. Now, following Bonku 1, supplemental tab 11, page 243, the 1971 ordinance was repealed and replaced by the 2000 ordinance, which you have in the core authorities at tab 3, page 21, and my learned friend Mr. Jaffe took you to that. But it's worth noting that all that section 4.3 of the 2000 ordinance did was to remove the need for a British dependent territory citizen to obtain permission to enter the outer island. There was an express carve-out for Diego Garcia, and it didn't confer any right of abode at all. It simply removed an impediment. And then we had the 2004 order, which is in the core and in relation to which the European Court of Human Rights, once it had been added to the challenge, which had originally started as a challenge to Mr. Justice Ousley, rejected the attack on that as well. So that's the true state of play in relation to direct local laws dealing with this. I'll come to common law in a second. But that's the position in relation to local law. The UK Parliament notes separately that the UK Parliament has also legislated in this field. It's done so to confer British citizenship on Chagosians meeting the criteria in Section 6 of the British Overseas Territories Act of 2002, Supplemental Authorities, tab 2, page 28. In circumstances in which, since the Immigration Act of 1971, British citizens have a right of abode in the UK. So those provisions specifically regulate right of abode, conferring it on the Ilois in those certain circumstances, those specified circumstances. But the right of abode there is specific. It's a right of abode in the United Kingdom, not a right of abode in the Violent. Note also, and thirdly, that the Crown has always owned and still owns all of the land in the Violent. So no private law interests associated with land were taken away or even impacted by the relevant decisions. They couldn't lawfully exercise any right of re-entry without Crown consent anyway, because the Crown was the landowner. So what is then said, it appears, is that the government should have conferred a right where none existed. But that doesn't mean that the decision engages fundamental rights as it stands. It's at most a prospective hope of having a right, as it were, conferred. But that turns on the merits of the rationality challenge itself. And that's very different to cases like book decay, which plainly do involve the exposure of an individual to a risk or a threat to life, because they've claimed asylum, and asylum is the context. Lord Justice Green was...
Yeah. Is your argument that there's no fundamental right engaged at all, or is it that one is engaged, but it's because of history and context and because of effects and legislative mitigation, that it is a properly balanced right? I understand Lord Hoffman's judgment in Echo number 2 to be to the latter. He rejected Sir Sidney Kettridge's submission that the right to vote was absolute, but he accepted that it existed. The paragraphs you cited to us from 53 onwards, as I understand it, he's saying that one needs to balance the existence of that right against the effects, practical effects. And he then cites all the matters that you've referred to and comes to the conclusion that it's impossible to say there's any sort of violation of public law. But I don't read him to be saying that there's no fundamental right engaged at all. It's just that it is heavily caveated and mitigated by context.
Well, I think that's a fair point, and I can take the latter way in which you put it contentedly, but I do invite the court to note that it appears that the House of Lords, particularly the majority in Bonku 2, proceeded on the assumption of a right of abode rather than actually deciding it. See for that Lord Hoffman, paras 44 and 45, Lord Roger 117, assuming Magna Carta was part of the law of Biot, and Lord Castle 124, which deals with the laws of England, not the laws of Biot. And the argument was simply whether any such right, however you characterised it, was defeasible. The answer was yes. And the core point remains, when we come to common law, the core point remains that the right was defeasible by local law. And we come to local law directly. So the submission is that there isn't a fundamental right, alternatively, the way my lord put it, in the alternative.
One reading of Lord Hoffman's judgment would be that he put it as simply the fundamental right to protest, if you read part way through paragraph 53. But I don't necessarily want to take up too much time with an analysis of paragraph 53.
No, but he certainly does refer to the right to protest, as it were, by way of, I think, by way of diminution. I'm not sure that entirely meets the force of my Lord Justice Green's point, which is, aren't they proceeding on the premise that there is a fundamental right involved, and then they get to whether it's defeasible, whether you rationally can have a go at it.
that's how I read 44 and 45. But as you say, the analysis of the court was that, assuming it exists, because of the context, it is defeasible.
That's all. That's the only reason I emphasise the point. They don't appear to have addressed or needed to grapple with the particular argument about local law.
But it seems to me it could have broader significance. Something I was thinking about in the context of Ms. Jaffe's submissions yesterday. His analysis takes one through the convention to get to the point that there is a right at issue which needs to be taken account of, whether it's under Article 8 or A1B1. And I rather read Mango number 2 as saying, although they don't look at it through the optic of the convention, they did find a fundamental right, but nonetheless they went through a detailed balancing exercise. So I was in my own mind querying whether, even if the convention applies, it necessarily leads to a different result, and if it did, how?
Well, my lord, I think the answer to that is that the first answer is that they appear to have assumed it as some species of right, not necessarily analysed as the ECHR right in the House of Lords. And I'll make some points about whether they were right to do that and quite how strong that right at common law might have been, whether it was defeasible by reference to local law as they ultimately held anyway. But the second thing to bear in mind is that Strasbourg brought its own approach to bear on that, which I'll deal with probably tomorrow now. And you will recall that, at least in the context of Article 8, they concluded that there was no interference, and they did so very much relying on the sort of analysis, and time has moved on and events have occurred and settlements have been paid, that you see reflected in Lord Hoffman at paragraph 53. And so it is to that forum and to that reasoning that we invite the court to pay particular attention when coming to that later issue. The only point here I'm on at the moment is, have we got, again, it can be a very esoteric debate for the sort of reasons that my Lord the Master of the Rolls pointed out in argument this morning, which is, aren't we really just dealing with a kind of vague sense of the importance of the interests involved? And there is basic and visceral truth in that. But we nevertheless submit that it is of some importance, whether you're doing the analysis as an absolute thing, there is no fundamental right, or whether you're doing it as a relative thing. If there is or was at some point some species of right, we better work out precisely what it was, even when it existed. And that's the reason I'm taking a little bit of time on this. I don't want to take much time.
Lord Hoffman, at paragraph 45, does say that the right of abode is a creature of the law. So he certainly recognised that. He says the law gives it and the law may take it away. In this context, I don't think it assists to call it a constitutional right. But he says, I quite accept that the right of abode, right to not be expelled from one's country, is an important right. That does seem to me to be perhaps one of the issues that we've been going around, which is really we're talking about how important is the right that we're talking that's in issue, and according to the importance of the right, you view it with you view the taking away of it or the lack of restoration of it, with greater or lesser concern. I mean, here the whole background to the whole of this is an acknowledgement, as you've emphasised, and it seems to be shown quite clearly in the documents, that everybody accepted at the highest government levels that a wrong had been committed. The question was it possible to put the matters back? Now, however you characterise a home, that's an important matter. I'm not sure, really, one can get very much further than that.
Well, maybe we don't, but the case that's being advanced against me, the case that's advanced against me is we have a fundamental right. That's to be taken as, and we're all agreed, at least the court and myself are agreed, I hope, that that's a relative thing. And so the question is, not merely has time moved on of the events that Lord Hoffman drew attention to, that I drew attention to happen, because even if it was an important thing in the past, to use a neutral word, time has moved on. All I'm on now is the point that said this isn't to be regarded as some sort of fundamental constitutional right of the kind that you see attracting Sims, or you see attracting all sorts of particular types of protection.
But
And I'm just
yes, I mean, one of the points Ms. Kaufman was making, of course, I think, in fact, for both counsel, Ms. Jaffe and Ms. Kaufman were making, they do place, of course, great weight on the advisory decision of the ICJ, which talks about the right to self-determination, which is a slightly different thing, but in this case it's connected.
It's a very different thing for
But I mean, I assume you're going to come back. I mean, when we're talking about rights of scrutiny and importance, one mustn't forget that's another limb to their argument, which they say is a very important point, which in itself, as it were, generates an obligation of anxious scrutiny.
My lord, that's true, and I'm going to come back to that very specifically. That's why I was toying with how to present the submissions, but I think it's probably easier to deal with the ICJ all in one block.
Certainly. Yes.
If that makes sense, or all in a block and a half, because some of it will go off into the ECHR analysis.
Yes.
Can I just briefly, with the common law, without wishing to overbore the court on the intricate detail of this, the position in relation to common law, just so you understand how it all works in relation to ceded colonies of this kind. Common law introduction to buyout has at all material times been subject to local laws. The common law doesn't extend automatically to a British overseas territory acquired by cession, as this one was. See for that proposition Bonku 2 per Lord Roger at 83 to 85. Not therefore possible for any common law right of abode to have been recognised as such until applied by domestic buyout legislation. And in this respect, Ms. Kaufman cited only from Lord Mance's speech in Bonku No. 2 about the right of abode and contended that the common law necessarily applied in the buyout. That, with greatest respect, is contrary to the analysis of Lord Roger, who was in the majority, see paragraph 79 to 84. And one of the documents that we sent to the court, I'm sorry for the plethora of additional materials, but it's tolerably short. I don't invite you to turn it up now, but it's there if you want it. One thing to note is that the 2017 version of Halsbury's Laws of England under the Commonwealth, paragraphs 705 and 711, which were the ones that we sent you, follow the approach of Lord Roger. If you have the first of the authorities bundles to hand, you will see that something of the attempt, as it were, to transpose common law into the buyout has been made. If you go to tab 2 and go to page 8 on the electronics, you will note, because my learned friend took you to it, both my learned friends I think took you to it, paragraph 3. But the critical thing to bear in mind,
Sorry, what's the reference?
my lord, I'm so sorry, tab 2 of the first of the core volumes of authorities,
Yes, thank you.
and I'm on paragraph 3, 3831. Friends emphasise the second half of that paragraph, and for reasons you will quite understand, I emphasise the first line and a half. So it made the common law part of buyout, but only insofar as it wasn't inconsistent with any specific local law, including prerogative orders, as Lord Roger noted at paragraph 85 of Bonku 2. And at that time, the grant of a right of abode would have been inconsistent with the Immigration Ordinance of 1971, which required, as I indicated earlier, a permit to enter or remain. Ultimately, the position has now been put beyond doubt well before the 2016 decision, by Section 9 of the 2004 Order, which again you've been taken to on a number of occasions, and I don't go back to. No person has the right of abode in the territory. So the core point remains, if anything confirmed by Bonku No. 2 in its basic analysis, which is that any common law right that either ever existed if it did, or might existed was always subject to local law. You don't just get the common law in British overseas territories, you need a specific instrument doing that. The instrument that did that contained the rider, subject to local law effectively. And local law there was, and local law there has been. So that's the second of the propositions. No fundamental right or a very attenuated right or flavour at best for all the reasons I've gone through. The third submission I make in relation to this heading on anxious scrutiny is that even if fundamental rights had been engaged and the anxious scrutiny approach had been applied, that would have altered the Divisional Court's approach in principle. Not a jot. Just as it didn't alter the House of Lords analysis in principle to this sort of challenge, a jot. Taken to the Smith case, it's in Core Authorities tab 11. I'll let it you this morning. It's page 184 is the first page. The key bits are at 221 to 223. And you will see that the analysis is all about, I will master the royal's question, I'll come to Con in a minute. The analysis is all about the proper approach that the court should adopt, the intensity of review that the court should adopt. And can I just invite you to remind yourselves, because it will be important when we come to Congo, and I don't want to go back to it, of what Lord Bridge of Harwich said in Brind. Sorry, in Bugdekai. At the bottom of page 221, just above the letter H, they cite from Lord Bridge in Bugdekai. And my learned friend Miss Kaufman was kind enough, I rely, and indeed I do, and I found it as being heavily reflected in the approach in Bonku number 2 of Lord Hoffman, in the paragraphs I invited you to read. The passage on which we particularly rely is between B and C on page 223. And that was the passage rightly relied on in the Divisional Court judgment at paragraph 108. So even if you've got a right of some weight in the blue corner, you still have the red corner, as it were, the governmental interest, the proper constitutional leeway to be afforded in a case such as this. The first point we make in principle relies on Smith. The second point we make is that even if this was an HRA challenge, a Human Rights Act challenge, you would still have the arguments that I spend most of my life deploying, which are to invite you to apply a big broad margin because the decision involves all the sorts of things I identified earlier. So even if you have some form of heightened scrutiny in the light of the interests involved properly analysed, it makes no difference. Anxious scrutiny, if you will, is only one facet of the rationality standard and has to be set in context. You don't go down a route of logic that goes fundamental rights, therefore anxious scrutiny, therefore you're jolly close to a merits challenge. That is simply not the correct approach in principle, even if anxious scrutiny works or is engaged. Sequel ticket.
Sorry, but just in relation to the human rights aspects, I don't think we necessarily need to get into it, but there are problems when you get the court having to decide the issue for itself, where obviously you will have a margin of appreciation, but there'll be different issues involved about legality.
There will certainly be different issues involved about legality, but there will be substantially the same constitutional underpinnings when you come to consider challenges to the substance of the decision that has been made. I don't know whether that quite addresses my Lord's question or thought, but it's those features that we respectfully submit are important, because the point that I'm making is, even if you assume for the purpose of this submission that anxious scrutiny is in play, you still have to factor in all of those considerations to do with macroeconomic and international relations and defence and security and all of that. And that provides, if you will, a levelling.
You get that from cases such as Lumsden, which says that when you're applying the proportionality test, again, the intensity review is highly context specific, and that then feeds into the extent to which the court confers upon the decision maker a margin of discretion.
Exactly so. I mean, Lumsden being particularly relevant, I could equally well have used I probably should have equally well used the analogy with EU law, where proportionality is the standard, and that was what Lumsden was about, was seeing to what extent there were differences in the approaches between HRA and EU law. There were some, but in this respect, there were none. And I'm not going to go back over that debate. I know my Lord and I have had that discussion already in other past cases, including cases involving red hats on cigarette packets. So that's the third submission. The fourth submission is that even if fundamental rights had been engaged and the anxious scrutiny approach is in play, there is nothing to support the proposition that would have altered the Divisional Court's conclusions on the facts, on the asserted errors in any shape or form. So the third submission was to do with principle, and the fourth one is to do with facts, which I will come back to, because I'm going to deal with that under what I described when I was giving you the roadmap as my submissions on the resurrected rationality challenge. Can I come briefly, before turning to two short final points on right of abode, to the point that my Lord the Master of the Rolls raised, which is, does it apply to the decision maker? And the submission I make about that is that Smith, ex parte Smith, pages 221 to 223, do not establish any such proposition. They are all about the court's role. The only authority that my learned friend cited in support of the proposition that you do the same thing when you come to the decision maker or something like it, it is the decision of the Court of Appeal in WM Congo. I can't quite remember where that went, but my version's got 3267 on the bottom of it. I don't know whether it went to the court or supplementary bundles.
I wonder if that is that the one that was right at the end? Is that the one that was right at the end of?
The one that was right at the end, yeah.
I think it was.
64 of the supplementary authorities bundle.
Yes, that's right. Yes.
Yeah, very good. And just to bear in mind are paragraph 7 that friend took you to.
That's right. Yes.
And the authority which is cited is to be noted. Look at the final sentence of paragraph 7. Right? That is the passage that Lord Bingham cited at the bottom of whatever page it was of Smith, at the bottom of page 221 of Smith. other passages that were cited from the speech of Lord Templeman by Lord Bingham.
But how does this work as a matter of logic? If, for the sake of argument, a court finds, applying in a proper case, anxious scrutiny, that a decision maker acted unlawfully, isn't that a conclusion that the decision maker should have applied greater scrutiny to the decision and found otherwise? I mean, a finding by a court that there is a breach applying anxious scrutiny, doesn't that necessarily connote that the decision maker should have acted likewise?
Well, I suppose it may do in some cases, or it may not. I mean, normally what anxious scrutiny what anxious scrutiny brings with it is a narrowing of the margin between concepts.
Yes, I understand it's a judicial doctrine, but it has connotations for a decision maker where fundamental rights are genuinely properly engaged. I just wonder if this really leads anywhere, if it really matters. If X hypothesides a case involving fundamental rights and the court has to apply anxious scrutiny, then the consequences for the decision maker simply flow.
Well, my lord, they may do. The reason I'm quibbling with it is, first of all, because it is entirely unsupported by properly analysed authority, and the second is a reason of principle, which I'll come to, which may go more directly to my lord's question. Just to finish the point of principle, you'll see that the only citation of authority for the proposition that is given in this part of Lord Justice Buxton's judgment is Lord Bridge in Bugdekai, which in a passage which had nothing to do with this issue at all. And then he reverts to the same point at the beginning of paragraph 10, see second sentence of that. But the second thing to bear in mind in relation to Congo, which may make it different and potentially explicable on its own facts, you see from paragraphs 1 and 6 of this judgment, which is in this context, in the context of the Congo case, the test was set out in 353 of the immigration laws, and that required the decision maker, in effect, to consider what a putative adjudicator would have made for new material. So you've got the intellectual complication of the relevant immigration rules requiring the decision maker to pretend that they were a court. So there may be some force in logic for applying that sort of principle in that sort of context, because what a court would do is say anxious scrutiny, if that's right, which is what it is, in the context of asylum. So we respectfully submit that Congo is not authoritative. Point of principle, which goes rather more directly to my lord's question, is that what I think my learned friend is seeking to do in relation to this is not to make a point that she thinks make no difference because of the logical attenuation that my lord has just referred to, but to try to say what this does is to impose a different standard or a greater degree of difficulty in the way of the decision maker when they are operating the process and when they are deciding what to take into account and when they are deciding how to approach the decision. And in relation to that, I respectfully submit, you would need some clear analysis and some clear authority, for the very simple reason that there is a substantial body of authority, which I took you through earlier on, Cartoon, DSD, and all of that, analysing how rationality works and applies in the context of the design of the decision-making process. And what my learned friend is trying to do by this submission, to import anxious scrutiny into that process, is to undermine that line of authority.
I think that is the point, isn't it, Sir James? I think the point you're making is that if you apply this test not only to the court but to the decision maker, you would say that's muddying two different things, and it's producing a confusion in the role of the court on the one hand, which is a scrutiny test, and based on rationality, and the obligation of the decision maker to act on a rational basis. And they are, in theory, two quite different functions, although the overlap is that the test that's applied, which is one of rationality, obviously applies in judging what's been done on the part of the decision maker. But I think what you're saying, I think you've said this effectively, is that if you seek to impose this test, particularly if you define it by means of a process, you are in fact making a gloss on what would otherwise be the rationality test.
Well, exactly so. But it's important for that reason. That's the
No,
reason
I
why
can see that.
My lord, I see the time.
Yes.
I'm going to have to go a bit tomorrow, but maybe I can shorten things overnight and try and get it critical. I want to spend a proper amount of time on the ICJ advisory opinion for obvious reasons and on the ECHR given the submissions made by my learned friend Mr. Jaffe in particular.
Yes, I think, I'm not sure what time we're starting, but I'm afraid it's slightly attenuated because I think I've got something in the morning. What time are we starting tomorrow, Matthew, do you know? At 2 o'clock. Yes, so we're starting again tomorrow at 2 o'clock. Thank you. Adjourned until 2 o'clock.